The United States Trade Secret System, Legal Framework, Strategic Value, and the Case for Secrecy over Disclosure. A research report by the Innovation Attorney. Executive Summary. Trade secret protection is the most widely used form of intellectual property protection in the United States, yet it receives far less attention than the patent system. The legal framework rests on two parallel pillars: the Defend Trade Secrets Act of 2016, codified at 18 U.S.C. Section 1836, which created the first federal civil cause of action for misappropriation, and the Uniform Trade Secrets Act, adopted in some form by 49 states plus the District of Columbia. Together, these statutes protect a broad category of commercially valuable information that derives its worth from remaining undisclosed, covering formulas, processes, customer lists, algorithms, and manufacturing methods that no other body of intellectual property law could reach. The strategic significance of trade secret protection has grown substantially since 2014, when the Supreme Court's decision in Alice Corporation v. CLS Bank International, 573 U.S. 208, made it materially harder to obtain patent protection for software, business methods, and algorithms. Companies that once pursued patent portfolios as a default strategy now weigh trade secret protection as an affirmative choice, not merely a fallback. The Coca-Cola formula, protected as a trade secret for well over a century, remains the most frequently cited example of this calculus. A patent would have disclosed the formula and expired within 20 years, while trade secret protection has lasted indefinitely. Litigation under the DDSA has produced verdicts of historic scale. In December 2024, a Massachusetts federal jury awarded Insulet Corporation $452 million against EOFlow Company Limited, finding willful and malicious misappropriation of trade secrets related to the Omnipod insulin delivery device. The court subsequently reduced that award to $59.4 million to avoid duplicative recovery alongside a permanent injunction, but the case illustrated the full remedial power available under 18 U.S.C. Section 1836b. 3. The central legal implication for businesses is clear. Trade secret protection demands proactive investment in reasonable secrecy measures because courts will not supply those measures retroactively. Detailed findings. The statutory framework. The federal trade secret system operates under two intersecting legal regimes. The Economic Espionage Act of 1996, codified at 18 U.S.C. Sections 1831 through 1839, established criminal liability for trade secret misappropriation, including a provision targeting theft for the benefit of foreign governments under Section 1831 and a broader commercial espionage provision under Section 1832. The Defend Trade Secrets Act of 2016 amended the EA to add a federal civil cause of action under Section 1836b, allowing trade secret owners to sue in federal district court without satisfying diversity jurisdiction requirements. Prior to the DDSA, trade secret owners were limited to state court claims under their state's version of the Uniform Trade Secrets Act. The UTSA, first promulgated in 1979 and amended in 1985, has been adopted in 49 states and the District of Columbia. New York remains the sole jurisdiction relying on common law trade secret principles, which developed through decades of decisions rooted in the restatement of torts. The UTSA defines a trade secret as information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value from not being generally known to or readily ascertainable by persons who could obtain economic value from its disclosure or use, and that is the subject of reasonable efforts to maintain its secrecy. The DTSA definition, at 18 U.S.C. Section 1839(3), tracks the UTSA language closely while adding specific reference to financial, business, scientific, technical, economic, and engineering information. Misappropriation under both statutes covers two scenarios: the acquisition of a trade secret by improper means, and the disclosure or use of a trade secret without consent by a person who knew or had reason to know that the secret was acquired improperly or under a duty of confidentiality. Improper means includes theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy, and espionage. The statute does not reach independent discovery or reverse engineering, both of which are recognized as legitimate competitive activities. The reasonable measures requirement. The most consequential operational requirement of trade secret law is the obligation to take measures that are reasonable under the circumstances to maintain the secrecy of the information. This element is evaluated by courts on a totality of the circumstances basis, and failure to satisfy it is fatal to a trade secret claim, regardless of how commercially valuable the underlying information may be. Courts have identified a consistent set of protective measures that, taken together, satisfy the reasonableness standard. Written confidentiality and non-disclosure agreements with employees and business partners. Need-to-know access controls limiting disclosure to personnel who require the information for their roles. Physical security measures controlling access to facilities and documents. Information technology controls, including access authentication and audit logging. Employee training on the existence and importance of the trade secrets. And exit procedures, ensuring departing employees understand their continuing obligations. Password-protected computer systems, standing alone, have been held insufficient. Courts have made clear that the existence of technical safeguards without parallel contractual obligations, such as non-disclosure agreements, does not satisfy the reasonable measures requirement. The lesson of cases like the McGuire-Woods analysis published in 2025 is that trade secret protection is a program, not a document. It requires sustained, coordinated effort across legal, human resources, and information security functions. The non-disclosure agreement occupies a central position in that program. A well-drafted NDA serves two functions simultaneously. It creates a contractual obligation enforceable on its own terms, and it constitutes documentary evidence that the company treated the information as confidential. Courts examining reasonable measures look favorably on NDAs executed at the inception of an employment or vendor relationship, accompanied by training that identifies the specific categories of information subject to protection. Generic language covering all company information has been found less persuasive than targeted provisions identifying specific trade secrets or categories. Remedies under the Defend Trade Secrets Act. The DTSA provides a remedial framework that is more powerful than most corporate counsel recognize. Section 1836(b) 3 authorizes injunctive relief to prevent any actual or threatened misappropriation, subject to a limitation that the injunction may not prevent a person from entering into an employment relationship and may not conflict with applicable state law. The injunction may be conditioned on the payment of a reasonable royalty, providing courts flexibility where a categorical prohibition would be disproportionate. Damages are recoverable in three forms: actual loss caused by the misappropriation, unjust enrichment caused by the misappropriation to the extent not captured by actual loss, and, as an alternative to damages based on loss and unjust enrichment, a reasonable royalty for the unauthorized use or disclosure. Where misappropriation is willful and malicious, the court may award exemplary damages not exceeding twice the damages otherwise recoverable. Attorney's fees are available against a party who willfully and maliciously misappropriates a trade secret or who makes a claim of misappropriation in bad faith. The DTSA's most distinctive procedural mechanism is the ex parte seizure order under Section 1836(b) 2. A court may, in extraordinary circumstances, order the seizure of property necessary to prevent the propagation or dissemination of the trade secret before the defendant has an opportunity to contest the order. The standard is demanding. The applicant must show that alternative remedies are inadequate, that immediate and irreparable injury will result without seizure, that the applicant's interest in the property outweighs the harm to the defendant, and that the person against whom seizure is sought would destroy or conceal the property if given notice. This mechanism is reserved for cases involving digital misappropriation, where information can be copied and transmitted instantaneously. The Insulet Corporation v. Oflow Company Limited matter illustrates the scope of available relief. The December 2024 jury award of $452 million, later reduced to $59.4 million to avoid duplication with the permanent injunction, nonetheless demonstrated that DTSA plaintiffs can pursue both injunctive relief, barring all further use of the misappropriated information, and substantial monetary recovery. The court also ordered the reassignment of patents that Oflo had obtained using Insulet's misappropriated technology, a remedy grounded in the unjust enrichment principle that a wrongdoer should not retain intellectual property rights built on stolen foundations. Extraterritorial application of the DTSA. The territorial reach of the DTSA was resolved for the first time at the circuit court level in 2024 in Motorola Solutions Incorporated v. Hitaera Communications Corporation, Limited, 108F.4 TH 458, 7th Circle 2024. The Seventh Circuit held that the DTSA rebuts the presumption against extraterritoriality, permitting recovery of worldwide damages caused by misappropriation, so long as an act in furtherance of the offense was committed in the United States. The court found that Hitaera's domestic advertising and marketing of products incorporating Motorola's misappropriated trade secrets constituted a qualifying domestic act. The Supreme Court declined to review the decision in February 2025, leaving the Seventh Circuit holding as the controlling federal appellate authority on extraterritorial reach. The practical significance of this ruling for multinational companies cannot be understated. A foreign competitor that acquires trade secrets through any means and markets the resulting products in the United States even modestly may face DSA liability for its entire global revenue stream attributable to the misappropriation. The domestic nexus threshold is low. The Seventh Circuit found that advertising and promotional activity within the United States satisfies the act in furtherance requirement without requiring that the act of misappropriation itself occur domestically. Trade secrets versus patent protection. The strategic analysis. The decision to protect commercially valuable information as a trade secret rather than seeking patent protection is one of the most consequential choices in IP strategy. The two systems are fundamentally different in structure, cost, duration, and the nature of the protection they provide. Patent protection under 35 U.S.C. sections 101 through 103 requires that the invention be novel, non-obvious, and directed to patentable subject matter. In exchange for meeting these requirements and publicly disclosing the invention in sufficient detail to enable a person of ordinary skill in the art to practice it, the patent owner receives an exclusive right to practice the invention for 20 years from the filing date. After expiration, the invention enters the public domain and competitors may practice it freely. Trade secret protection requires none of these elements. There is no novelty requirement. Information need only be not generally known and not readily ascertainable, which is a substantially lower threshold than patent novelty. There is no non-obviousness requirement. There is no disclosure requirement. The entire premise of trade secret protection is that the information remains undisclosed, and there is no fixed term. Trade secret protection persists as long as the information remains secret and the owner maintains reasonable measures to protect it. The Coca-Cola formula has been protected as a trade secret since the late 19th century, a duration that would have been impossible under the patent system. The post-Alice environment has materially shifted the calculus for software and technology companies. Alice Corporation v. CLS Bank International, 573 U.S. 208, 2014, and its progeny under 35 U.S.C. Section 101 created substantial uncertainty about the patentability of software, business methods, and algorithms. Of 27 software-related patents reviewed for subject matter eligibility in one analyzed appellate period, only 4 were found partially or fully eligible. Companies developing machine learning models, proprietary algorithms, training data preprocessing pipelines, and recommendation systems face a credible risk that patent applications directed to these innovations will be rejected under Section 101 as directed to abstract ideas. Trade secret protection avoids this risk entirely, imposing no subject matter eligibility filter. 5 distinct scenarios favor trade secret protection over patent filing. First, where the information is not susceptible to reverse engineering from the marketed product, trade secret protection may be effectively perpetual. A manufacturing process that produces a commercially available product without disclosing the process itself is a classic example. Second, where the competitive advantage is expected to outlast the 20-year patent term, as in the Coca-Cola case, trade secret protection preserves the advantage indefinitely. Third, where the cost and delay of patent prosecution are prohibitive relative to the commercial window, Trade secret protection is available immediately upon reasonable measures being taken. Fourth, where the innovation would not survive Section 101 scrutiny, such as many AI and software-based inventions, trade secret protection is the only available IP vehicle. Fifth, where disclosure of the invention to a competitor through the patent application process, which is published 18 months after filing, would cause more harm than the eventual patent protection would provide. Secrecy is the rational choice. Patent protection retains decisive advantages in specific circumstances, where a competitor can reverse engineer the product or independently discover the innovation. Patent protection creates an exclusivity right that trade secret law cannot provide. A patent bars all unauthorized use regardless of independent development, while trade secret law does not, where the company's business model depends on licensing the technology to multiple parties. A patent provides a clear, recordable legal right that supports commercial licensing in a way that secrecy does not, where the company anticipates needing to assert the right in litigation. A patent creates a presumptively valid right, whereas trade secret misappropriation requires proof of specific wrongful conduct, and where the company seeks to use the IP right as collateral for financing. Patents are more readily accepted as collateral than trade secrets. The FTC non-compete rule and its effect on trade secret strategy. On April 23, 2024, the Federal Trade Commission issued a final rule that would have banned most non-compete agreements in employment nationwide. The rule was vacated by the United States District Court for the Northern District of Texas on August 20, 2024, in Ryan LLC v. FTC. But the regulatory effort signaled a long-term policy direction that trade secret practitioners must monitor. If a comprehensive federal ban on non-competes is ultimately sustained, the inevitable disclosure doctrine, which allows employers to seek injunctive relief, preventing a departing employee from working for a competitor where the employee would inevitably use the employer's trade secrets, would become the primary mechanism for restricting competitive employment. The doctrine is currently recognized in approximately half of the states, with no federal consensus, and imposes a high evidentiary burden before relief is granted. The practical consequence for companies that have historically relied on non-competes as a backstop to trade secret programs is that the NDA and the Trade Secret Protection Program itself must carry the full weight of protection. Courts examining inevitable disclosure claims scrutinize the specificity of the identified trade secrets, the degree of overlap between the employee's prior role and the new role, and the nature of the competitive harm. Companies that cannot point to specific, identified, and properly protected trade secrets will struggle to obtain inevitable disclosure relief regardless of jurisdictional doctrine. C. Legal and regulatory implications. The DTSA at 18 U.S.C. Section 1836 b. 1 requires that misappropriation relate to a product or service used in, or intended for use in, interstate or foreign commerce. This jurisdictional hook is construed broadly and does not require that the trade secret itself cross state lines. The use of electronic communication infrastructure, financial systems, or commercial channels ordinarily satisfies the requirement. Plaintiffs have generally had no difficulty meeting this threshold. The DTSA's whistleblower immunity provision at 18 U.S.C. Section 1833 b. creates an obligation that employers must satisfy to take advantage of exemplary damages and attorney's fees. An employer may not recover these enhanced remedies unless it has provided notice of the immunity provision in any contract or agreement with an employee, contractor, or consultant that governs the use of trade secrets or other confidential information. The immunity protects disclosure of trade secrets to attorneys or government officials in connection with reporting suspected violations of law. Companies that fail to include this notice language in their confidentiality agreements lose access to the full remedial arsenal. The 3-year statute of limitations under the UTSA and the analogous limitation period applicable to DTSA claims runs from the date of actual or constructive discovery of the misappropriation. The discovery rule creates a continuing tension in cases involving ongoing use of trade secrets. The statute may run separately on each new act of misappropriation, or it may run from the initial act of theft, depending on jurisdiction and the specific theory of harm asserted. Plaintiffs must identify the earliest date of known or knowable misappropriation and file accordingly, or risk losing claims on limitations grounds. The inevitable disclosure doctrine, where recognized, has significant First Amendment and labor mobility implications. Courts applying the doctrine must balance the employer's interest in protecting trade secrets against the employee's constitutional interest in pursuing a chosen occupation. The Supreme Court has not directly addressed the doctrine, and the circuit courts have not produced a uniform national standard. In jurisdictions that apply heightened scrutiny to inevitable disclosure claims, employers should expect to demonstrate specific, particularized harm rather than relying on the theoretical risk that a knowledgeable employee might disclose information in a new role. The Economic Espionage Act criminal provisions carry penalties of up to 15 years imprisonment and fines of up to $5 million for individual defendants under Section 1832, and fines of up to $5 million per count or 3 times the value of the stolen trade secret for organizations where theft is for the benefit of a foreign government under Section 1831. The penalties are doubled. The Department of Justice has prosecuted a growing number of EEA cases, reflecting both increased enforcement priority and the growing awareness of state-sponsored industrial espionage as a national security concern. Open questions. The extraterritorial scope of the DDSA, following the Seventh Circuit's ruling in Motorola Solutions versus Hidera, remains unresolved at the Supreme Court level. The question of what constitutes a sufficient domestic act in furtherance of foreign misappropriation has been addressed by only one circuit, and the threshold established by the Seventh Circuit may not reflect how other circuits will analyze the issue. Companies with operations in multiple jurisdictions should anticipate divergent outcomes until the Supreme Court or Congress clarifies the standard. The fate of the FTC non-compete rule remains uncertain. The Northern District of Texas vacated the rule on administrative law grounds in 2024, but the underlying policy question has not been resolved, and future administrations or a differently constituted FTC could promulgate a revised rule. If non-competes are ultimately banned nationally, the weight placed on trade secret protection programs will increase substantially, and the inevitable disclosure doctrine will face a new round of judicial scrutiny. The intersection of artificial intelligence and trade secret law presents unresolved questions about the nature of protectable information in machine learning contexts. Whether a trained model's weights constitute a trade secret, what reasonable measures are required to protect them, and whether the output of a model can constitute misappropriation of the training data are all questions that courts have not yet fully addressed. The rapid commercial deployment of large language models and foundation models will force these issues into litigation within the next several years. The adequacy of trade secret protection for information embedded in supply chain relationships raises ongoing questions about the reach of reasonable measures obligations. When a company discloses trade secrets to a supplier or contract manufacturer under a confidentiality agreement, and the supplier subsequently allows the information to be accessed by a foreign entity, the question of whether the original owner's reasonable measures were adequate is litigated under a standard that has not been comprehensively defined by the courts. Congress has not revisited the DTSA since its enactment in 2016. The statute was drafted before the current period of aggressive AI development, widespread remote work, and the normalization of cloud-based data storage. Whether the existing statutory definitions and remedial structure are adequate for the trade secret challenges of the current environment is an open question that the legal and business communities have begun to raise in policy forums.